Last week, a leaked draft opinion authored by Justice Samuel Alito showed that the court was poised to overturn Roe v. Wade, the landmark 73 case that protects abortion rights nationwide, in a case concerning a strict Mississippi abortion law.
Joining us on the KOGO News Live Line, legal analyst Rob Crain. And Rob, first of all, what would overturning Roe v. Wade do right away?
Well, it would trigger a lot of what's called trigger laws in 13 states, which said that, passed by the state legislatures, that if Roe v. Wade is overturned, our state law automatically bans abortion. So Roe v. Wade would take the decision about abortion away from the Supreme Court, the judiciary, and put it either in the federal government's hand to legislate, which our Senate and House have not done. And without that, it then goes to the states that can legislate with their governors and state legislators. So 13 states would automatically trigger abortion bans. There are other states that already had laws banning abortion on the books before Roe v. Wade was decided. Those would go back into effect. So that 23 states would, pretty quickly after Roe, have a ban on abortion.
Critics of that draft decision believe that if the opinion is ultimately rendered, it represents an opening salvo in a push to target other rights grounded in either privacy or liberty, same-sex marriage, even buying birth control. True or no?
Well, that's the big talk. And in reading the previous opinions by Justice Alito wrote a dissent in the Obergefell, the same-sex marriage opinion, which he writes a lot of the same things from that dissent into this majority opinion. So that's the argument, is he is saying that the right to privacy is not listed in the Constitution, a right to an abortion is not listed in the Constitution, and except in very, very limited circumstances, we're not going to place a unstated right into law. And he goes down a long description as to his thoughts on that process. But the reality is that same-sex marriage, same-sex intimacy, contraception are all rooted in the same grounding of the 14th Amendment and somewhat of the 9th Amendment. And so there is going to be this argument that if you take down Roe under this argument, then you're taking down these other unenumerated, unlisted rights in the Constitution. So it's a bit of a slippery slope.
All right. Legal analyst Rob Crain, thank you for your time this morning.
Anytime.